Hi, this is Curt and welcome to another edition of Fire Law Roundup. We want to cover today a class or a case that we kind of slipped off of our radar, and it involves the FMLA. And in particular, this is an area that Brad has quickly become the go-to person in the fire service when it comes to FMLA issues. And although we kind of missed it when it originally happened, I really want to spend some time because to me, it's a good example of the importance of knowing the FMLA so that we can avoid these kinds of problems. So, but Brad, take it away.
Very good. And look, I'm going to say, as we always say, these are allegations. This isn't a court decision. We don't have findings of fact yet. And more of what I'm going to comment on is about things we don't know. And so there'll be a lot of comments, but we'll do a short recitation of the facts. And I think a lot of the value in this is going to be the banter between us. So here we're in Illinois, and a fire chief who is under a 3-year contract, and there are 2 3-year contracts. They renew it, and I think that's important. We just don't know why yet. But he's a contracted employee. And he was terminated. I'll explain why, but the allegation claims that his termination violated the Americans with Disabilities Act and his rights under the Family Medical Leave Act. So he was terminated in 21, and he was the chief since 2016. So from 2016, at some point for 3 years, he's got his first 3-year contract. And then in 19, presumably, he signs a 2nd-year contract. And it matters because, A, I don't have the contract, and the contract could, if we're in good or worse for one side or the other, could dictate a lot of the answers in this. So we don't know, but we'll talk about that. In any event, he has a history, and I don't know, I just want to point out, I don't know if the history was known to his employer in the first 3-year contract. That would matter to me also on this. But he has a history of having a lot of illnesses that hospitalize him and prohibit him from being able to do his job, of which is 9/10 or 95% administrative, he claims. That's going to matter under the ADA, maybe, because there's still 5 or 10% that's not administrative. Nonetheless, he gets COVID, he gets sick. When he is sick, he in the hospital, the administration places him on, he's on a leave, right? But the deputy chief then takes over to do his job, and he stays in touch with that chief and going back and forth on issues. So in August of 21, he's hospitalized. He's admitted for testing. Later, he contacts his administrative assistant to say, listen, I'm not going to be there due to me being in the hospital. So again, the employer knows he's hospitalized, and as we'll talk about later, may know why, may know that he has a history. That'll be important. And then the next day after that, he contacts the assistant fire chief to say, listen, we got to talk about business, but I'm not going to be there. And there's a board meeting that's regularly scheduled tonight. We should talk about. And then the next day, as he's still in the hospital, he receives a text message from a trustee. And we'll talk about the trustees, that I have a time-sensitive document you need to receive. Now, let me just start here. If you have an employee in the hospital and you're delivering them time-sensitive documents, you're nuts. Let's just start there. Short of it being a beneficiary designation, let's not serve people in the hospital when they're, being tested and treated. In any event, at some point thereafter, he receives a letter saying that he's being temporarily relieved of all fire chief duties and placed on a paid medical leave. And they did so under the guise of focusing on your health, which I don't really have a huge issue with. In any event, the letter says, listen, the assistant chief is going to remain as the acting fire chief. We'll talk about all that and intermittent leaves under the FMLA. But then the chief is locked out of his email and such. That's an interesting point. Later that day, he's now discharged from the hospital. He calls the trustees, say, listen, I want to come back. I'm getting a note. And ultimately, he gets a return to work letter. And then after that, sorry, you're terminated. Skipping a couple of things, couple of meetings, but he ultimately is terminated despite getting a job clearance letter. And he then sues, saying, well, you violated the ADA because you didn't provide me a reasonable accommodation. You and I need to spend some time on that. And then he says, and you violated my Family and Medical Leave Act rights. And I will talk about that as well. But let me tell you about a few documents we don't have to my knowledge. Despite a reference to it, I did not see his job description and his job duties in anything we had, and that is critical under the ADA. So my first question is, do we have that?
I don't think so. Not unless
Okay,
it's, I don't see it as an attachment.
No, and they make reference to it, but I don't think it was in anything that I actually saw attached to the complaint.
No, I don't see it.
But clearly, so let's talk about ADA for a minute, right? So he describes his job as 90 or 95% administrative, which most fire chiefs of larger areas would agree. But that still leaves 10%, which he may not have been able to go to. And by the way, I should mention, the reason this got discovered is he was driving into work, he crashed his car and was found unconscious. So he's already doing a work activity involving responding to a vehicle where he can't be, right? He can't do the job.
Yeah, and that was early in his career. That wasn't just before he was terminated. That was years before that. So I think what you're getting at is the department was on notice that he had some medical issues. And that's important also for the FMLA, more so than the ADA.
But they allow him to continue doing his job after that fact. And so question number one is, what are your job duties? Question number two is, can you do them, and are they reasonable duties? Question number three, if the ADA applies, which it would here, presumably, can you reasonably accommodate that? And look, reasonably accommodating somebody's job doesn't mean relieving them of the duties of their job, saying, okay, well, you don't have to go to the big structure fires or the big calls. That's not a reasonable accommodation. Saying, well, somebody else will go in your place forever is not a reasonable accommodation. But the other, in my view, the other thing we don't have
could be a short-term accommodation.
That would be okay,
yeah.
Right? That would be okay. The second thing we don't have is the contract. So there's a lot that could be in the contract. More importantly, on the leave issue and family medical, which we'll hold on for a second. But here, so the question of whether they could have or should have reasonably accommodated, there's one very interesting fact here, which is this is a new board. A new board, right, comes in and then says, we're not doing this.
Within a very short period of time.
Very short period of time. Yeah. But the new board is still going to be held to, but your entity knew all of these things and didn't seem to care. Now you seem to care. And that raises a very important question of law. And let me put it out because I don't know the answer. If an employer is over generous to its employee, contracted employee, for 2 or 3 years, saying we don't have to provide you benefits, but we're going to. We don't have to accommodate the fact that you might be a danger to your job to 5% of your duties. But
I don't see that as being a fact here. But
I don't think it's a fact. But the fact is that for 3 years, this is never an issue.
Right.
Now the new board comes in and then is not going to tolerate it. So the question I throw out, and I don't have an answer, is the new board held to a higher standard of tolerance or of accommodation just because the prior board may have been more lenient? Right. Very interesting question to me.
Well, I think if the prior board granted a reasonable accommodation, is the new board under an obligation to continue it?
Or an unreasonable? How about a overly generous, right? Beyond reasonable.
Well, yeah, I mean, I don't know if that's, here it seems like he was sick a couple of times and they put the deputy in charge and he took sick leave or whatever. And, they got by it the first couple of years. And then the second 3 years he had a couple and, it's really about the use of sick leave, and some of it may have been injury related. It was cancer in there. One of the diagnoses. COVID was another one, which in some places is work related. So maybe you got a mix here of sick leave and workers' comp claims. But I think from my reading of it, the problem is you get this new board, and they felt like they needed to move on from this particular chief. and which is understandable, but you got to do it right.
Well, and a key missing component, at least from what we see, is the letter clearing him to do his duties doesn't seem to have any restrictions on it. We don't know it doesn't, but there's no reference to that. So since there are no restrictions, what is there to accommodate? Right? So now we move to the FMLA, because what I don't know is how much sick time he has. He's granted his 12 weeks, right, of sick leave. He should be anyway. We don't know how much he had. We don't, and so I'm just throwing out what we don't know just before we comment. We don't know how much sick leave he had. We don't know how much he used, and we don't know which of the 4 methods the employer uses to calculate the 12 weeks of sick time. Looking forward, looking back, calendar year, etc. So we don't.
If you don't understand what he just said, you need to go to the class on the FMLA, because what he just said is very, very important. And we're not going to have the time to explain it all, but that's very, very important. I'm sorry, Brett.
No, I'm glad you said that. And this is, the reason we do the FMLA lecture, this is so complicated. And let me point out things we don't know, which I hope they did. We also don't know if the beneficiary's notice was given. We don't know if, let me keep this in layperson's terms for this. We don't know if the employer gave all the required by federal law notices to the employee. We don't know what the contract says about sick leave. We don't know what the policies are on concurrent paid leave with concurrent not. So we don't know a lot of this. And unfortunately, and I don't mean to be critical, I apologize to the attorney in advance. We're not trying to Monday morning quarterback, even though it's Monday morning. We're not trying to Monday morning quarterback everything. But the complaint is not written as I would write it, my style anyway, on the FMLA. So let's talk about FMLA very quickly, although it's a significant component of this, because he could get his back wages and he could get good money from FMLA. FMLA has 2 or 3 causes of action that people can sue under. I say 2 or 3 because different federal courts combine one of them, some leave it separate. But basically it's, I interfered with your right to use FMLA leave, your 12 weeks. I don't think that's here based on the facts, but that seems to be alleged. There's also,
it could be. And here's to me, the most important, this lays out the fact pattern for one of the most important things about the FMLA. When someone is off, whatever it may be, they're off, as long as it's a sickness or illness, that type of thing, or family sickness, okay? But they're off, and you don't designate it as FMLA qualifying leave, okay? And then they're off again, and then they're off again, and then they're off again, and then they're off again. They might have been off for 6 months total in the course of a year. If you didn't designate that leave as FMLA qualifying, when you go to terminate them, they got another 12 weeks. You terminated them without allowing them to exhaust their FMLA leave, because just the fact that they call in sick does not trigger the FMLA. And fire departments have got to understand this. If you're going to deal with sick leave abuse, if you're going to deal with people not coming to work, you have to comply with the FMLA, or else this scenario right here, this department could find themselves thinking that they did everything right, and then they're going to find out that they violated the FMLA because they didn't designate the time that this chief took as FMLA qualifying.
And unfortunately, that's what I'm saying. The complaint just doesn't outline the facts necessary for us to make solid conclusions. Was this, if this was an interference claim, maybe it was, maybe it wasn't. But we don't really know. But the other part of this are also discrimination claims. We're discriminating you because you wanted to use your time. That wasn't very well outlined in the lawsuit itself. But clearly that should be very well outlined. If it was me, I'd be amending the claim to state interference, to state retaliation, right? And there are key components. You interfered. I had X weeks left, which we don't know of the 12 weeks, or I got more in contract or whatever, and you interfered with my use of that because you fired me before that time, right? Or that would be a fair interference claim. Discrimination is I tried to use it and you discriminated against me for using it. I don't know if that's here, but it could be. And that's what I'm saying. We shouldn't have to say, I don't know to any of this. And then lastly is retaliation, which I do see here, that you retaliated against me because I used my FMLA time. They will come back and say, no, we determined that you're unable to fulfill the job requirements without any accommodation, or without any reasonable accommodation. The problem is he's got a letter back from his doctor. So let me talk very quickly about intermittent leave. So intermittent leave is, the first 3 quarters is exactly what you said. If an employer comes to learn or knows that an employee is out for a qualifying condition under the Family Medical Leave Act, and then comes back and then goes out again. Now, the employer has knowledge that it's an intermittent leave, right? Meaning it's not one block, I'm going out for pregnancy, I'll be back when I'm coming. It's a chronic recurring condition. The employee has obligations too, however, and we can't tell whether he fulfilled them or not. Now here, it doesn't look like he knew he was going out, but the question is, what did he tell the employer? Right now, he's in the hospital. But
well, they knew he was in the hospital because they wanted to serve him some paper that they had to serve him with.
Right, and if you're in the hospital, right, one overnight stay, which it was, automatically qualifies for FMLA leave. Now, whether they knew it was related to a prior condition is different, but either way, on intermittent leave, the employee, and under FMLA anyway, the employer, let's start with this, the employer has the right to appoint an assistant, to appoint somebody to fill in. No problem, there's nothing wrong with that. They can do it. And while the employee's out, hey, you have the right to be replaced. But the moment the employee says, I am cleared to return to work and do not need any more intermittent leaves, which we don't 100% know is the case here. Like I said, I would have drafted this complaint answering all these questions, not one little statement like they gave here, so we don't know the answers. But if the employee says, my return to work is unconditional, as I think it is here, based on what we can tell, and I don't need any more leaves, that's the key question, then he has the right to reinstatement and not be terminated as they did. So one thing we don't know, I don't know how much leave he took. I don't know if his contract gave him more leave. It can't abridge it. It can't take away his 12 weeks, but he could, maybe he used the time.
And maybe they did document the FMLA. So that's one of those things we just don't know. But to me, the fact pattern lends itself to the importance of knowing the FMLA and understanding the consequences that if you don't hit those check boxes and document that the leave has been designated as FMLA qualifying, you could have somebody who's a problem employee. And I'm not saying he is, but I'm just saying if you're dealing with sick leave problems, sick leave abuse problems, somebody who's off, they're off. When you go to try to discipline them or terminate them, if you can't prove that they took their 12 weeks under the FMLA, you've got a problem.
Right. And let me say this for anyone listening saying, do we have a problem or not? This is where I would start. Right now, if you want to figure out if you are prepared or not prepared, go to your employee manual, pull out the FMLA policy. If your FMLA policy is less than, I'm going to say, about 10 pages, you are not providing enough notice to the employee of their rights, because there are at least 10 pages of rights. Now, the federal government does it in a couple less than that, and they refer to some things with links. But if you do not state every one of your employees' rights and your employer's rights, then your FMLA policy is probably seriously lacking, and you should be attending. This is not an advertisement for it, but you should be attending our FMLA lecture, because you are going to put yourself or your employee in a bad position of either leaving yourself exposed to suit or allowing your employee to sue you based on FMLA violations. And FMLA is incredibly complicated. It is not easy. It's hundreds of pages of statute and regs and opinions and thousands of cases. If something was easy, there would not be thousands of cases. Go look at your FMLA policy. If it's too short, you need to get on board.
Yeah, there's nothing in our development as fire officers that prepares us for this. Looking at how people did it in the past, not a good benchmark for what we need to be doing to comply with the FMLA. And if you have a good HR department and they're on top of this, then God bless you. But if you have questions or you're not sure, we've got one. I'm not even sure the date it's coming up, but we run them on a regular basis, and we hope to hope to see you at one of the upcoming
Well,
classes.
and let me jump in with this. If you're a frontline supervisor, lieutenant, captain, or above, and you have not been trained on how to react to somebody calling in sick or saying, boy, I had this leg pain and I had to go see the doctor. If you are not trained and you don't feel comfortable knowing how to react, whether it's just a referral or understanding the trigger announcement that your employee is making by telling you about a sickness, illness, condition, pregnancy, whatever, if you are not trained in that, you need to get trained, and your HR department isn't doing the best job it can at preventing or addressing these issues.
Yeah. All right. And that's going to do it for another edition of Fire Law